We are live.
Okay, thank you. I must comment that I can't help but observe that our counselors are a little more prompt at the end of breaks when we're electronically meeting as opposed to in chambers. So for those clerk-like people who don't like electronic meetings, there's at least one additional advantage to them. With that, we are now returning to our meeting at approximately 1:33. And I believe that Mr. Fedori has joined us to respond to Councillor Douglas's question that she had just before we broke with regards to septic inspection authority.
Yes, Councillor Douglas, if you could just re-ask your question, just in case I didn't clarify it enough for our CBO, that would be appreciated. Thank you.
Okay. Hi, Dave. Thanks for joining us. Dave, there's a lot of concerns about whether or not the septic system that they're putting in, should it fail, whether the MECP will actually come out and do regular inspections. It seems that there are some that are saying that in fact, that's not happened with other facilities for numerous years, which I'm quite concerned about. If they aren't doing it and we have some issues, is there some way that we as a township, or you as in that particular area, can step in to do our own inspections and put a separate agreement together over top of the MECP?
You're on.
We don't have any jurisdiction. Once it's over 10,000 liters per day, it's got nothing to do with us. You can maybe stipulate that the engineer that's doing the job has them come out and look at it and verify everything. Other than that, it's once, like I say, once it's over 10,000 liters per day, it's got nothing to do with the Township of Georgian Bay Building Department.
Okay, just to keep along the stream then, when you say the engineer, are you talking about our engineer from the municipality?
No, usually they have an engineer that submits the plans for any of these septic systems that are over 10,000 liters per day. You'd have to ask the ministry if they're going to actually physically go out on site and look at it.
Can we, if I may just continue on this vein of thought, do we have a possibility to have some agreement with MECP? Maybe this is a question for Jamie or for Krista Zika, that stipulates that they must indicate, how often they come out, or that they come out once a year, or whatever we ask for, to inspect this until we're satisfied over a period of time, or maybe it's indefinitely, I don't know. And I understand what you're saying, we have no jurisdiction, but is there a possibility of putting a clause in there that allows the township to step on and even if it's with our own engineers, to make our own assessment so we can make a report to MECP? Do we have any, I understand what you're saying, we don't have jurisdiction, but do we have a possibility of having that in the contract?
So if they're putting in a tertiary system that's over there, which I would think that they would do, there is a maintenance agreement that will have to take place with that. Depends on which system is going in, how they're servicing it and everything else. Like if it's a Waterloo or anything like that, there is a maintenance agreement that is done every year. So we could ask for some records and stuff like that.
Okay. Okay. I'm just trying to get some sort of assurances if we don't entirely have faith. Well, unfortunately I have to say that, but if there are some that don't have faith in the MECP, and there is some sort of an inspection program that goes along with the tertiary system, if we can request records and then have an ability to reach out to MECP, or just something that gives us more assurance that this is actually being taken care of and looked at. I understand that the township probably doesn't have jurisdiction to step in, but is there some not backup, but some additional steps that we can take to have some eyes on in a way or another?
Through your worship, maybe I can try to answer that question. If you recall, with the Brandy's Island system, we requested a peer review to be completed of the work that was submitted. So we could, like council could request a peer review, or as part of the monitoring, have a review of the results of the the system monitoring reviewed on an annual basis, for example, or on a biannual basis, or whatever council decides. And then council can convey those results to the ministry and provide the ministry with a copy of what they've reviewed at any point in time. And the ministry can decide whether there's action to be taken on the system or not. But I agree with Dave. All we would be doing is commenting on the system, and we would never have jurisdiction over it. The jurisdiction lies with the ministry. But it sounds like what you're interested in is just making sure it's a belt and suspenders approach, that just in case they aren't looking at it yearly, that there is somebody, and we can do that. There's a cost associated with doing that, though, to the municipality.
Okay. That answered my question. Thanks, Dave. I do understand that the township has no jurisdiction, but it would be good to have another overseeing ability is what I'm thinking. So it's just something that I think we should consider. And whether that is at the expense of the township or something that we try to negotiate out with the proponents, I just think it's worth the discussion at least. Thanks, Dave, for your time.
No problem.
Thank you very much, Mr. Fedori. Appreciate you joining our meeting, if briefly. All right. The masked one. Clerk Way, I believe you, in conjunction with Mr. Robinson, had drafted up a resolution for our review. Because I understand, Mr. Robinson, you're more technically astute than our clerk at this particular moment.
Not
Okay.
my fault.
I don't know about that.
Well, I understand that she's been having some equipment challenges. Can I put it that way?
So, Your Worship, if you'd like, I could share my screen, and just in the PowerPoint presentation that I'd provided earlier, we've got a copy of some revised resolutions that if council would like to look at those, I can add them to the screen.
That might give us a good starting point in our discussion.
So the real key modifications, just maybe so I can point them out to you as you read through them, was the two key items that the clerk and I believed we heard was related to the monitoring program. Sorry, the 90 units being limited until there was such time that there was an amendment to the site plan agreement to consider additional units. And then also we heard about the monitoring program being included, and my notes showed that it was for 10 years following the issuance or 10 years from the completion of the development. So we included 10 years following the issuance of a building permit. And then I have two options here, one that included a left-hand turn lane, and another one that doesn't include that left-hand turn lane. I know there's discussion about it, but I don't think anyone actually requested that be added to the revised resolution.
Okay, so.
Oh, sorry. Yeah, this is the correct one here. Sorry.
So this particular one does not include the left-hand turn lane.
Correct.
But you've added in the 90 units to address all peer review with agreement limiting the number of units to 9 units until such time that an amendment to the site plan agreement is submitted and considered. So like it's a stepping stone. And then a water monitoring program shall be also required throughout the development of the site for a period of 10 years following the issuance of the final building permit unit. Council. Two questions. One, does this capture your wishes in regards to the 90 units and the water monitoring? And secondly, do you or do you not want to see the turning lane as part of it? And thirdly, any other comments? And I'll have to try to page through here to see if I see Councillor Cooper's hand is up, followed by Councillor Wienko, and I may have got that in the wrong order, but I got Cooper and Wienko so far.
Thank you, Mayor. I guess my
sort of thoughts over lunch were that there's a lot of moving parts here. And I really would think that it might make some sense for us to consider this agreement over the next few days, including getting counsel on it, legal counsel, etc. And we're sort of trying to add this, but not that. And I think we may forget some things and then feel that it's insufficient. So I would think that it might make some sense to have a few days to build this properly, and then have once we get sort of more or less consensus, have a meeting, short Zoom meeting to approve it in a week's time, shall we say. Just a suggestion.
A suggestion which makes a lot of sense depending upon how the next, I'll say the next half hour goes. Councilor Wienko. Councilor Wojcik with your hand up. So you'll be next.
A couple of suggestions. If you, the water monitoring program, if you put water/wetlands, that would be sufficient. I think you need a wetlands in there too. So water/wetland monitoring program shall be required for the development. The other thing too, I do support the idea of the turn lane. Again, I'll let other councilors decide, but I think that I'm supportive of the turn lane. And thirdly, I think in follow up to Councillor Douglas's concern and what Dave Fedori was saying, can't we ask for an annual report on the operations of the septic system? In other words, leave it up to the proponent to prepare an annual report on the performance of the septic system or the sewage system, and leave it at that. Now, it could be the same report that they send to the Ministry of the Environment, or it could be a separate report or whatever, but it gives council and staff an opportunity to look at the performance of that system on an annual basis. I don't think that's really a hardship requirement, because they may be doing it for the MECP anyway. So why don't we just ask for that report each year and make a condition on this site plan?
Through your worship, if I may, just to that point, they are required, to look at it during the break, they are required to submit a report to MOE, the applicants are, every year, and they will share that with the township. So I'm not sure it's something that needs to be added to the resolution.
I think it should be in the resolution, just to firm it up so we can always go back to it and say, you know, we made that requirement. It may be redundant, but I think it's a good idea.
Well, all right, I'm looking for further hands and I'm flicking back and forth. So if you raised your hand before and I didn't recognize you, you can do it again. Okay. Councillor Wojcik, followed by Councillor Douglas. I think I saw your hand.
Thank you, Mayor. I'm still a little miffed about the lack of concern that there was no public meetings leading up to this. And that leads me to the point, Jamie, until such a time there's amendment to the site plan agreement, this amendment process that could happen in the future, would it, or is it possible to mandate public meetings before or during the amendment process to the site plan?
Through your worship, no.
That's what I figured. So we've really gone through this whole process without hearing from our public and their concerns, which we have on many other cases that I've sat and made decisions on. So if your question is, do you want the left-hand turn lane included in this resolution? I don't think it really matters, because I don't really think this is going to go very far. I'm fine to submit the lesser of the two, which doesn't include the left-hand turn lane, in hopes that maybe we strike a chord with the proponent and we do approve the 90 units. But I would like to see the public process be entered into this somewhere. And you say it's not mandated. is there a possibility to do it even if it's not mandated, if council agrees to have this done?
Through your worship, yes, and there has been, like, I don't think it's a fair characterization that there has not been a public process or the public opportunity for comment on this. There's been a larger opportunity for public comment than I've ever experienced in any site plan application ever. And I'll describe what that is for you. All of the information has been available on the township's website for a number of years as it's been provided. The requirement is that the information be available at the township office in the file. The township's taken the step to make it available to the public. The public's been advised numerous times to submit comments throughout the process if they have comments. The township hosted an open house meeting, which is not required to do, which is well over and above what the Planning Act requirements are, so the public could review a copy of the application and have direct access to the peer review consultants. So to suggest there's been no consultation at all with the public on this, I don't think is a fair characterization of the process. What is true is there's been no statutory public meeting at council. And the reason for that is because we're not allowed to have one because the Planning Act doesn't prescribe it. So my answer to your questions are yes, no, we cannot have a statutory public meeting like we would for a zoning bylaw amendment. This is a different application under different legislation. But could you hold an open house meeting? Absolutely, you could hold an open house meeting. Is it standard to hold an open house meeting for site plan applications? Absolutely not. But this municipality and this council has gone well beyond what the Planning Act requires in terms of processing a site plan application and ensuring public have an opportunity to comment. I just want to make that clear because I've heard a number of times today that we have not, that the township has not done that. And I don't think it's a fair characterization.
Further to that, Jamie, I guess your point being when it's a zoning amendment, there is a public process and public meetings, which we've seen in Vaughan about 8 years ago about the amendment to the docks. And during the official plan, we had many public meetings at the community center where council, people such as yourself attended, and there was a public forum for a question and answer period, which I think is just due diligence in this case. And you're saying it's not mandated. I have to rely on your professional opinion. I sure would have liked to have seen a lot of, most of my constituents feel they've never had an opportunity to speak face to face on the matter. They've written their letters. They've done what they can according to the rules that are in place, but they still wanted that face to face with all of council there, with all the representatives there, with the developer there. And I don't think that the open house that we had, it wasn't statutory and there's really no backbone to it. So I was hoping that we would, if we approve this resolution, that during the process after the 90 units, there would be public input. And you've given me my answer. Thank you, Jamie.
Councillor Douglas?
I would be in favor of the turning lane. I know Councillor Bochek said maybe that's not necessary, but I do think that with the additional traffic that could really stall things on the ingoing road. I would like to see that go in the resolution and I would support it. Going forward for if we're asking whether we can have public consultation, I think I would agree with Jamie that there has been a lot of opportunity. Would it be nice to have another public meeting? Yes, maybe not a statutory one, but if we can have another one that obviously that was achieved before and that could be possible going forward. But I also would agree with Councillor Wianco that we should probably, even though it may be redundant to put it in there, but have another statement in there that says that we are the report for the septic system on a yearly basis that goes to the MECP also come to the township, just so we know for sure we've got some sort of some finger on the pulse on that one. Thank you.
Okay. Councillor Jarvis or Councillor Hazelton, do you wish to speak to this? Councillor Jarvis.
Well, I think Councillor Cooper had his hand up as well, or maybe he's already spoken. One, I like the idea of, thank you, Councillor Bianca, for adding wetlands into that for monitoring. I agree with the redundancy idea on the MOECP report, just because I seem to recall, if we go back to Oak Bay, way back when, it was required that they provide water testing reports, and but the municipality never saw them if they were furnished, and we want to make sure this stuff is available. So yeah, left-hand turn lane. Of course, I use Honey Harbor Road a lot, and I seem to recall that in one of the reports early on with regards to the roads that a left-hand turn lane was recommended. I presume in the negotiations afterwards it was taken out, but I'm pretty sure I saw it at some point in there. I'm not sure. My only issue there would be who would be paying for it, because I expect that would be a substantial change to the road and would require significant financial input from somebody. And the only way I see that coming from the municipality, not from the developer. But maybe we can do it that way. Anyway, I would be okay with the left-hand turn lane being added in, but I wouldn't be so keen on the municipality paying for it. Otherwise, looks like good. The changes look good to me.
Just to clarify through your worship, if it's added, it would be the responsibility of the developer, not the municipality.
Thank you.
Councillor Hazelton, do you want to add anything before Councillor Cooper starts round two?
Sure. Are we first of all, I provided some draft amendment to the resolution that has somehow never found its light of day. I've provided some draft bylaws that hasn't somehow provided its light of day. I think it's absolutely critical, if we're going to approve a resolution, that we connect the resolution to the bylaws. And so we have a site plan agreement here. We're suggesting we're going to enact some bylaw, but that bylaw doesn't constrain things to 90 units. We're suggesting that we're going to remove the holding symbol, but that the wording that I'm seeing in front of us doesn't constrain this to the 90 units. I think that those are absolutely critical elements that need to be connected. We wouldn't want to have a bylaw that somebody comes along in the future and says, well, this is unconstrained. Sadly, we have seen challenges where there are two sources of knowledge, and whoever is working the situation picks the one that's most convenient for them. So we do need to connect those two and that clauses. I'm also a strong supporter of this turn lane. However, I would, in my opinion, that's not going to be something needed day one. That may be something that we would want to, is kind of a concession, you know, wait till they build out, 40 or 50 units, then redo the traffic study and see if a turn lane is needed. And this is obviously complicated wording, but I think it's first of all critical that a turn lane is likely going to be needed at a 90 unit build out. But I wouldn't want to impose that constraint day one. So we're back to how do we get visibility into the progress of this project? And at what point in time do we start triggering other things? Because in fact, the road itself may need to be expanded to handle all the traffic. If you look at the site plan, the developer's already proposing 270 some odd parking spots. and other people are suggesting, the traffic of, 350 or more vehicles throughout a weekend, that's likely going to trigger road improvements as well as a turn lane requirement. So there are some things that we need to be monitoring, and accommodations in the future that would be funded by the developer because they are not requirements of the community or the residents of our township, based on what's there today.
Okay. I'll let this go to a second round in a moment. I'm just wondering, further to Councillor Hazelton's comments, whether or not the left-hand turn lane could be part of the, I'll call it the second agreement we're suggesting here, that after the first 90, if the developer wishes to go past 90 units and build the 91st, so to speak, that application for the second site plan agreement, whether that might include a left-hand turn lane, because at that point, hopefully we'd have some information about how much traffic volume has been added during the first couple of years of development. So I know Councillor Cooper had his hand up, and I saw Councillor Douglas's hand go up. Councillor Cooper. Oh, Ms. Wade, did you want to interrupt?
Sorry, I just wanted to note that I do have Councillor Hazelton's motion that he sent me if I need to share that on the screen.
Oh, okay.
So I will take your direction for that, but I do have it available that I can bring it up.
Okay. All right, thank you. Councillor Cooper.
Thank you, Mayor Kurtz here. I guess I go back to my comment earlier about doing this on the fly. There's a lot of things that are fairly technical in nature, including the fact that a public meeting isn't required for a site plan agreement. It is my understanding, however, that we did miss opportunities for public meetings as it pertains to other aspects of this development. So, and I'm very heartened to hear what Councilor Bochak has said about this, that the public is expecting and has expected and has wanted to make comment. And it's not just sending in notes and letters, it's been broader than that. And so my comments weren't necessarily critical of what our consultants been doing, but rather, or the process that the municipal law requires, but our people want to speak. And so I think we need to figure out a way to get that in there, along with a few other things. Like, I think what Councillor Hazelton's talking about is that in order to have this airtight, we may need to look at a change to bylaw as well. So that's another consideration. There's a whole bunch of other things. There was one point we were talking about something, and I felt we needed to add the words hold harmless. I can't even remember what that was, where it was related. So I guess my point is that there's just so many things that I think doing this on the fly today may be ill-advised. Thank you.
Thank you. Councillor Douglas.
Well, just a couple of things here. Just in regards to the turning lane, I really, if we're going to do a turning lane, I personally would think that's needed right away, because if you've ever lined up behind a dump truck trying to turn into a development with no line of sight, it can be, well, I think it'd be quite dangerous. So I really think if you're going to put a turn lane in, we actually need it, right away, just for the construction end of it with large equipment going in. But that's just my opinion on that. As far as what Councillor Cooper is saying, I'm not sure that I disagree with what he has to say. I actually think that it's not maybe a bad idea that we try to get through a process today and get it down to a few things that we would like to see go in that, but then take a couple of days and maybe call a special meeting to just give us a bit of time to absorb that and maybe make some word changes that we feel is necessary, and then come back at it to, if that's possible, to do a deferral for a couple of days and do a special meeting. I would be in agreement to that, and that would give us an opportunity to look at the wording and make a decision whether we feel that we need to add something more to it to be more substantial.
Thank you. Any other comments? Councillor Wojcik, followed by Councillor Yanko.
Yeah, in round three, I think I made it perfectly clear when it came to making a decision that I was not in favor of approving this application. And we've gone from that to striking a resolution which adds amendments to it. And now we're at the point where we're looking for a deferral. I have obtained independent legal advice on this matter, and really a deferral I don't think is what we're looking for. I do agree that it's a lot to absorb in a short amount of time, but through countless hours of reading and everything else, I know where I stand on this issue, and would be able to either support this amendment in this resolution moving forward, or just deny the application based on all the information that I have. So if the rest of council is wanting to defer this, I think there's implications in the deferral that you'll find out later, but I'm not willing to disclose right now. Thank you.
Councillor Yanko.
Okay, I'm in support of basically what we have on the screen here today, and I'm willing to vote on it today. I don't think we need to wait another couple of days. What I'm quite concerned about is if this gets denied, if we're looking at this particular resolution now and it gets denied, I want to get some feedback from Chris. Is this resolution, the new wording in this resolution, defensible at an LPAT if the proponent decided to go tomorrow to the LPAT? Is there defensible issues in here that he's comfortable with, or is there things in here that he's not comfortable with? Because there's no use passing something and it's not defendable at an LPAT. So I wouldn't mind hearing from Chris as to what his feelings are with this new resolution or this modified resolution that we have in front of us.
Is Chris there?
Mr. Tazikas or
Scrap?
Sorry, can I be heard now?
yes.
You can be heard now. Sorry, can I just advise that this question may or may not be able to be answered in open session? Not that we can go into closed session, but I will leave that discretion up to you, Chris.
No, I was thinking the exact same thing, Karen. Thank you. I think it would be better if I gave this advice to council in a closed meeting, but I do indicate to you that if this resolution is something that finds favor with council, it should be tweaked slightly so that council authorizes the entering into of a site plan agreement as amended. And I also agree with the points that Councillor Hazelton was making, that the bylaws that are proposed for enactment should be modified so that they fit or dovetail with the resolution that you are providing.
Thank you. And I just want to add to that, if I may, is that the resolution that we're proposing here is to approve a site plan application with modification. The proponent will then have an opportunity to come back with a yay or nay to the proposed modifications. Like this is, and we may find in a couple of weeks' time that they agree to two components and not the third, for instance. So I don't think that the discussion of whether or not this is defendable in LPAT, I think that's a little bit premature, because what this is, in my mind, because if we don't approve the site plan application as it appears, means we're keeping the negotiation open a little bit longer. At least that's my non-qualified interpretation.
Chris, do you want to comment on that or myself?
Jamie, you can go ahead and comment if you wish. I'll add anything if I think necessary.
Certainly. So, Your Worship, my understanding is if council passes this resolution, they'll be approving the site plan agreement as amended with the additional requirements that are included in the amendment here today. They would be passing the bylaw, and there's no opportunity for additional negotiation to take place with the applicant, other than that if the applicant were to appeal council's decision, then there could be negotiations take place as part of any potential settlement in advance of an appeal. But what's being tabled with this resolution is just that, is a decision to approve on the basis of some specific additional requirements. Chris, if there's anything you can add.
I think respectfully, I mean, what the mayor is suggesting is that if this resolution is enacted and we get a reaction from the proponent that is okay with some of what's in here, but not okay with other things, that we would come back to council and have it reconsider its decision.
Oh, okay. I see. Okay, sorry, as I'm clear.
Yeah, I would like to suggest that what we're adding to this is, I think, very reasonable modifications, which I would hope that the developer would respect the intent. And the intent certainly is not to shut the project down. The intent is to add a couple extra conditions that we think would add a great deal of comfort to it with regards to the residents, especially in the immediate area, as well as our concerns over the environment. And so we're not, let's see, this is not an aggressive anti-proponent maneuver. This is, in my mind, just adding a couple extra items to make it a much more, or make it a more positive relationship and agreement. And so I hope that the proponent would understand that intent. Having said that, we as a council, I think, pretty soon have to make a decision of whether what is in front of us is worthy of a vote, or if I know there's some people, a couple of us suggested a possible deferral for a couple of weeks. I'm hesitant to do that simply because I think the items that we want to have added to the agreement we have now noted. And so I think this is very clear instruction as to how the site plan, how we'd like to see the site plan agreement modified before it is signed. Councillor Bocek.
In listening to the responses from my fellow councillors, I do believe there was 3 in favor of including the left-hand turn lane on Honey Harbor Road. I may have to have a recount on that. But if it takes a 4th in order to have that put onto the resolution, then I would agree with the adopting that into the resolution as well too.
I believe that was the first version that was put in front of us, was it not, Mr. Robinson?
That's correct. And this version does not have it. I can add it if council desires.
Yeah, we've made modifications to this resolution so that aren't included on the one with the left-hand turn lane. So if we were to add it to this one, it would be inclusive of all the new information that you've added. So, and I would support that as well, Mr. Mayor.
Okay. Thank you. So now the key paragraph, and I understand that the bylaw 2020-048 will be modified to match this resolution? Do we have to state that clearly, or is that just an assumption we can make?
It's process. You don't have to state that clearly.
Councillor Hazelton, you're still muted, Councillor Hazelton.
We heard from our, thank you. We heard from our legal counsel that we need to be putting in as amended into these to and that clauses. So I think that's absolutely critical. And
It's been done.
I see that. I was just hoping that we were going to see a completed final version before, because we were stuck on an old version and we were talking, but we weren't getting an updated version.
Okay. So now we have a modified resolution that reads, be it resolved that council received a site plan application by HHMB Limited Partnership and removal of holding symbol H application for 380 Macy Bay Road report. And that in keeping with the Ontario Municipal Board decision relating to case number PL 140356 issued on March 16, 2017, council approves the site plan application submitted by HHMB Limited Partnership and supporting documentation as amended to address all peer review comments with the agreement limiting the number of units to 90 units until such time that an amendment to the site plan agreement is submitted and considered. A water wetland monitoring program shall also be required throughout the development of the site and for a period of 10 years following the issuance of the final building permit unit. The proponent shall provide their yearly MECP report on the sewage system to the township for review. A left-hand turn lane on Honey Harbor Road shall also be a requirement of site plan approval. And that council authorizes the entering into a site plan agreement and enacts bylaw 2020-048 as amended, and that council authorizes the removal of the holding symbol applying to 380 Macy Bay Road on the basis that the requirements for lifting of the holding symbol H as outlined in column 6 of the table applying to the CT2-6 zone have been satisfied and enacts bylaw 2020-049 to remove the holding symbol.
What happened to the as amended clauses? They got taken out.
It just got added back in. Bylaw 2020-049 as amended.
And then 2020-48.
Oh, it was there. It was there when I read it.
I know, it's gone now.
Maybe I was on the wrong, hold on one second here. Sorry, it skipped pages on me there by accident. My apologies. We're good now.
Okay. So
it's page, this was page 20.
Okay, so
now
page
it's jumped down to page 21.
Okay, so we're now back on page 20. All right, now, is there any counselor who's not prepared to vote on this? Okay, and with that, I will call the vote. All those in favor of this resolution as it has been amended now. I see 1, 2, 3, 4, 5, 6, and I make 7. So we're passing this resolution with allowing Macy Bay to go ahead with their development, subject to a couple of additional conditions that we want to have incorporated into that site plan agreement. Council, thank you very much for this discussion. It has been quite lengthy, but I think quite fruitful. And I think that what I also appreciate is, in spite of all the concerns that were expressed, it's been quite a positive conversation in which we're wanting to make sure that the Macy Bay development respects the wishes of the residents and the environment, but while at the same time allowing them to move farther ahead with this project in accordance with the OMB ruling of 2017. Thank you very much. And as that was the only part of the Planning Council, we have a couple of further resolutions moved by Councillor Wienko, seconded by Councillor Bocek, Be it resolved that Planning Council adopts bylaw 2020-051, being a bylaw to confirm the proceedings of the July 13th, 2020 Planning Council meeting. All those in favor? And be it resolved that council does now adjourn at 2:17 p.m. until Monday, August 10th, 2020 at 10 a.m. or at the call of the chair. All those in favor? All right, this means adjourn, but don't go anywhere. The next discussion is, shall we get a little bit of our council meeting in this afternoon, or shall we save it all until tomorrow? I'm not even sure how long the council meeting as a total will take, though I do know at 10 o'clock we have the audit report happening to start off tomorrow morning. Our clerk and ex-clerk, based on all your lifetime